Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. After a few weeks with excellent wins for non-citizens, we have a 4-case week with all losses. Such is life of a circuit watcher when he's watching for immigration decisions. Plus, this final Ninth Circuit case is one of the more complicated cases that I've ever seen. I shall do my best to rise to the challenge. Also, in personal and professional news, I had the pleasure of spending time this week with the leadership and volunteer members of the American Bar Association's Commission on Immigration during their pro bono trip and fall business meeting held in San Diego. Lucky commission. The Immigration Bar is fortunate to have these hardworking people fighting on our behalf and defending the most vulnerable populations. And their vital nonprofit sub-organizations like IJP in San Diego and ProBar in Harlingen, Texas, sometimes seem to be the only thing holding the border together. Thank you for everything you do, ABA. For your work, I give you these cases. Alright, let's do it! Zapata-Chacon v. Garland, published by the 10th Circuit on October 25th, 2022. Haven't seen the 10th Circuit in months, it seems, but the 10th is back to deny a crimmigration type motion to reopen. Mr. Zapata-Chacon is from Mexico, but became a conditional lawful permanent resident in the late 1990s based on his marriage to a U.S. citizen. In 1998, he was arrested for suspicion of possessing cocaine. But he ultimately, quote, pleaded guilty to one Class 5 felony of possession of more than 8 ounces of marijuana in violation of Section 18-18-4064B of the Colorado Revised Statutes, end quote. I see the panel is firmly in the pleaded camp rather than pled. I don't often tell circuit courts that they're wrong, but 10th Circuit panel, you're wrong. Mr. Zapata-Chacon didn't serve any time because former INS quite quickly sought his removal, quote, identifying his Colorado marijuana conviction as an offense relating to a controlled substance, end quote, under INA Section 237A2B. I'm sure case law said it was at the time, and facing prison, Mr. Zapata-Chacon conceded removability and was removed to Mexico. Over the next few years, he re-entered or attempted to re-enter the U.S. more than once, unlawfully. Perhaps to be with his U.S. citizen spouse? Undiscussed. This all resulted in a reinstated removal order and a federal criminal conviction under 8 U.S.C. Section 1326 for illegal re-entry. He returned nevertheless again in 2005 and remained undetected until 2020, when he filed a motion to reconsider and terminate in immigration court of that first initial removal order. And that's because by this point in 2020, Mr. Zapata-Chacon had at least the 8th Circuit decision in Gonzalez, not to mention the soon-to-be-decided 11th Circuit decision in Syed, explaining that states that criminalize possession of marijuana stalks criminalize more conduct than do the feds in their criminalization of possessing marijuana. The feds, it would appear, only criminalize possession of the smokable portions of marijuana. As the 8th Circuit and 11th Circuit have now explained, that makes states that criminalize stalks, seeds, stems, and all that stuff overbroad vis-a-vis the federal definition of marijuana, making simple possession of marijuana in the 8th and the 11th Circuit not a removable offense, at least when it comes to Florida possession of marijuana. Apparently, Colorado had a similar definition of marijuana in the late 1990s. That is, Colorado criminalized possession of marijuana stalks. And so Mr. Zapata-Chacon argued that he was not actually removable in the first place during that first removal hearing. He made this argument despite, it appears, conceding removability, and despite DHS's prior reinstatement of that final order and a federal conviction tethered to that final removal order. It's not a crazy argument, it's just a difficult one to make, particularly because it was 20 years untimely. And for that reason, the immigration judge denied it. And so did the BIA. But the 10th Circuit actually went even farther, or that is to say, it stopped the motion in its tracks. Because according to the court, due to Mr. Zapata-Chacon's unlawful entries and at least one reinstatement, INA Section 241A5 barred it from entertaining any motion to reconsider or reopen in the first place. No jurisdiction. The 10th Circuit so held even though the BIA never raised the issue, nor did OIL until after briefing had concluded. And that's because this is about jurisdiction, and the 10th Circuit believed that neither it, nor the IJ, nor the BIA had authority to entertain the motion in the first place. A court consider its own jurisdiction at any time. Quote, based on its plain language, Section 241A5 prohibits 3 things once a non-citizen illegally re-enters and authorities reinstate his removal order. 1. The reopening of a prior order of removal. 2. The review of a prior order of removal. And 3. A non-citizen's eligibility to apply for any relief. Even if the first prohibition does not apply to Mr. Zapata-Chacon's motion to reconsider, the latter 2 do. End quote. In non-legalese, even if the 1999 removal order was wrong as a matter of law, INA Section 241A5 is a stubbornly powerful thing, and both Congress and the courts are okay with its potentially inequitable results. The 10th Circuit reached this ruling even though DHS never actually reinstated the 1999 removal order the last time Mr. Zapata-Chacon entered the United States. To the court, it was enough that a reinstatement had occurred during a prior unlawful entry in the past. The 10th Circuit appears to agree that Section 241A5 actually, quote, does not constrain our jurisdiction to review legal and constitutional questions, end quote, but apparently that exception wasn't at play here. Mr. Zapata-Chacon therefore did not get his case reconsidered, and we must wait another day for the 10th Circuit to join the freight train of a bandwagon, taking down the removal consequences of marijuana possession. Colorado might be up next. And there's this. In reaching this holding, the 10th Circuit held that, quote, reconsideration of a prior decision is widely understood as seeking relief from the prior decision, end quote. That's why the third Section 241A5 rationale applied in this case. Recall, the statute prevents individuals like Mr. Zapata-Chacon, quote, to apply for any relief, end quote. Not gonna lie though, I'm not sure that squares with the INA and lots of case law, that is, that reconsideration is relief, but the 10th Circuit brought case law of its own, so there you go. But consider this. If, for example, reconsideration is relief as understood by the INA, would that mean, for example, that a frivolous asylum finding bars reconsideration of a frivolous asylum finding? Because after all, a frivolous asylum finding bars a non-citizen from obtaining all benefits under the INA, and relief is certainly a benefit. So does that mean under the rationale of this decision, an asylum applicant could never get a frivolous asylum finding reconsidered even if a timely motion is filed? Seems like a bit of a problem. Or I'm wrong. Also, nice section of law on this one for all the ways the 10th Circuit believes the BIA can abuse its discretion. For what it's worth, and to try to identify some good petition for reviewers in the 10th Circuit. And that is Zapata-Chacon v. Garland. Next is Morales v. Garland, published by the Fourth Circuit on October 24th, 2022. This case is about particular social groups. Ms. Morales is from El Salvador and entered the United States at 53 years old, without authorization, by crossing one of the more dangerous rivers in the world. According to the court, which was undoubtedly relying on DHS border records, quote, questioned at that time by a Border Patrol agent, Ms. Morales explained that she had come to the United States to look for work and denied fearing persecution or torture in El Salvador, end quote. Weeks later, detained in an immigration court, she requested an opportunity to apply for asylum. She posted bond and moved to Maryland to be with her adult son. At her eventual final hearing, Ms. Morales testified that, quote, she had been raped by a cousin in El Salvador and abused by an ex-partner who fathered her son, left her, returned, and is now deceased, end quote. The cousin is still alive and threatened her as recently as 2015. He hasn't harmed her, however, since the 1970s. She has also helped police investigate an MS-13 robbery, testifying about what she had seen. Quote, a few days later, 3 unknown men with tattoos came by her house and threatened her with a gun, end quote. She filed a police report and fled to the United States a month later. Since her departure, a niece, nephew, and uncle have been killed, possibly, she believed, in retaliation by MS-13. An immigration judge and then the BIA denied, and the Fourth Circuit upheld those denials. As always discussed on the pod, to obtain asylum or withholding of removal, it's not sufficient to simply fear death or serious harm. The non-citizen must fear it for the right reason. That is, on account of one of the 5 protected grounds. And as the Fourth Circuit candidly states, quote, of all the protected classes, membership in a particular social group has created the most definitional difficulty. Human beings are social by nature. Many, if not most, belong to multiple social groups, thus leaving that ground for asylum one of perennially uncertain application, end quote. Amen to that. To be a cognizable particular social group, the group must entail an immutable characteristic, defined with particularity, and be socially distinct. A ball of mush definition that the BIA and circuits have endeavored to clearly define for at least 4 decades now. And while unmentioned here, the Fourth Circuit has the most non-citizen-friendly case law on the particularity prong. To meet it, essentially as I read precedent, the non-citizen must simply do a good job drafting the describing characteristic. The description must simply be written with, quote, definable boundaries so it is sufficiently clear who is in and out, end quote. While the social distinction prong requires an inquiry into a society's views, particularity in the Fourth Circuit just needs to be written well. That's my reading of the case law. Take it for what it's worth. Anyway, Ms. Moreno proffered her particular social groups as 1, Salvadoran women who are witnesses to gang criminal activity and targeted because they filed a police report, 2, Salvadoran women who are in a domestic relationship that they are unable to leave, and 3, family. The Fourth Circuit took each in turn. The Fourth Circuit held that the first group wasn't particular. It was too amorphous. Witnesses and criminal activity, for example, refer to a wide group of people in a wide variety of ways and contexts. Not particular enough to the court. Nor did Ms. Morales show that Salvadoran society views such people as a group, as social distinction requires. The Fourth Circuit kind of relies on a bit of unfortunate logic for this point, though. Namely, although the Department of State reports show that the Salvadoran government uses, quote, abysmal efforts, end quote, to keep witnesses to gang crime safe, the Fourth Circuit reasoned that, quote, the Salvadoran government fails to keep all kinds of people safe, end quote. To the Fourth Circuit, then, that meant that there is nothing special or distinct about the Salvadoran government's inability to keep witnesses to gang crime safe, because everyone is unsafe in El Salvador. Not great. As to the group Salvadoran women who are in a domestic relationship that they are unable to leave, that's nearly the matter of ARCG group, but Ms. Morales, quote, has not demonstrated herself even to belong to this group, end quote. Her abusive partner has passed away, and the relationship with her cousin, forced as it may have been, ended 40 years ago. Concluding then with the group of family, it can be cognizable under Fourth Circuit precedent, Hernandez-Avalos v. Lynch, However, Ms. Morales didn't show that she was harmed or feared harm because of her family membership, aka a no nexus finding, said the court. For example, quote, that her cousin supposedly raped her and not a stranger does not mean that he did so on account of family membership, end quote. Turning then briefly to the Convention Against Torture, which doesn't require a nexus to a protected ground, well, Ms. Morales had failed to bring the challenge to the BIA, so the Fourth Circuit deemed the issue waived. And that means Ms. Morales lost her case. And that is Morales v. Garland. Moving on to the Fifth Circuit with Guevara-Fabian v. Garland, published on October 25th, 2022. Short is an understatement with this one. It's 2 pages. And half of the first page is case title information. Ms. Guevara-Fabian and her child are asylum seekers from El Salvador. The immigration judge and the BIA denied the application. The BIA without opinion. Ms. Guevara-Fabian sought asylum based on her membership in the proposed particular social group that she describes as, quote, family member of Jose Amadeo Fabian, end quote. Jose Fabian is her uncle, and, quote, he was attacked and beaten after he refused to carry contraband into the prison where he worked, end quote, in El Salvador. Looks like Miss Guevara-Fabian was extorted after that, but even assuming that this is a valid particular social group, and even assuming that extortion is persecution, the IJ, BIA, and now Fifth Circuit didn't believe that Miss Guevara-Fabian's connection to Mr. Fabian, her uncle, was the reason. Rather, according to the court, it was because she owned a profitable business. Not only that, she has family in El Salvador that remain in that country unharmed. So the Fifth Circuit upheld the agency's denial. Remember, I told you it was short. The next case, however, is very long. And that is Guevara-Fabian v. Garland. To conclude the week, we have Mendoza-Linares v. Garland, published by the Ninth Circuit on October 24th, 2022. This is a big old decision on credible fear review and jurisdiction. Judge Graber dissented. Mr. Mendoza-Linares is from El Salvador and entered the United States without authorization. According to the Ninth Circuit, he hopped a fence and was caught immediately in the United States. Immigration officials believed he didn't have a credible fear of persecution and, having no right to be in the U.S. under immigration law, ordered him expeditiously removed. According to the court, which like the Fourth Circuit before it, was surely relying on a summary of the encounter created by a DHS subagency, Mr. Mendoza-Linares, quote, stated that he had left El Salvador in order to be with his girlfriend, who lived in Vista, California. Mr. Mendoza-Linares answered no when asked whether he had any fear or concern about being returned to El Salvador and whether he would be harmed if returned there, end quote. Later on, though, likely from detention and after the expedited removal order, but I guess before it was executed, Mr. Mendoza-Linares did indeed express a fear. That expression of fear occurred, it appears, after DHS gave him and other non-citizens in detention an orientation about their rights under asylum law and the credible fear process. In this second interview, Mr. Mendoza-Linares expressed a fear of gangs in El Salvador. He said that he had been a DJ in that country, and political candidates required that he repeat pro-government anti-gang messages during his sets. Quote, that, he said, led to a half-dozen incidents of assault by gang members, including throwing rocks or shooting at a bus he was riding, end quote. And his DJ posters were defaced with gang graffiti. Unique claim. He was also worried that, quote, his tattoos, which consisted of a koi fish, his daughter's name, barcodes with his and his daughter's birthdays, and the comedy-tragedy theater faces, would be mistaken for gang tattoos, end quote. The asylum officer decided against Mr. Mendoza-Linares on the merits of his credible fear claim. And the reason for the no credible fear finding are a bit unexplained by the Ninth Circuit, but one at least is not. The asylum officer relied on the Trump administration's transit bar then in effect. That transit bar was a particularly cruel attempt by the Trump administration to prevent individuals, mainly from Guatemala, El Salvador, and Honduras, from obtaining asylum in the United States, even if they had the clearest and most well-founded fears imaginable. The bar made it such that anyone, quote, who arrived in the U.S. across the southern border after transiting through at least one country outside the non-citizen's country of citizenship, nationality, or last habitual residence en route to the United States is categorically ineligible for asylum, end quote. And obviously the country of Mexico encompasses the entire southern border of the United States. I believe the bar lasted about 8 months before a federal judge found it unlawful. Mr. Mendoza-Linares, it would appear, hopped the fence during that 8 months, or at least during a period when the Supreme Court of the United States overturned a lower court and decided to let the transit bar go into effect pending litigation. Quote, 22 days after Mr. Mendoza-Linares filed his petition for review in this court, the Ninth Circuit, a district court subsequently vacated the regulations, end quote. But here we are. The transit bar never prevented withholding and cat protection, but the asylum officer also determined that Mr. Mendoza-Linares didn't have a reasonable fear of persecution or torture that would permit him to apply for those forms of relief and protection. The asylum officer didn't believe there was a reasonable possibility that Mr. Mendoza-Linares could obtain withholding or cat. I guess? To be honest, I'm a bit confused if the Ninth Circuit is talking about some special reasonable fear standard applicable only to transit bar cases. Because here the Ninth Circuit states that, quote, if the transit bar applies, the non-citizen must instead show a well-founded fear of persecution or a reasonable fear of torture, end quote. Emphasis by the court. The Ninth Circuit believes that the reasonable fear standard used in transit bar cases has a substantive requirement. The non-citizen needs to prove his or her case right then and there. That's not my understanding of normal reasonable fear interviews, and if it's transit bar specific, well, those are gone, so long as immigration advocates vote in 2024. Anyway, to return to Mr. Mendoza-Linares, he has been found to not have a credible fear or a reasonable fear. He appealed those no credible and reasonable fear findings to an immigration judge, who affirmed the asylum officer. The immigration judge affirmed despite, by the way, believing that the asylum officer had erred in determining that the past harm to Mr. Mendoza-Linares didn't rise to the level of past persecution. But like the asylum officer, it appears, the IJ didn't see a fear of gangs to be a fear based on a cognizable, protected group. At least in this case. That means it all skips the BIA and goes directly to the Ninth Circuit, because these are not INA Section 240 removal proceedings. They're expedited Section 235 proceedings. If it goes anywhere at all for review, it goes to the Circuit Court of Appeals, which in this case is the Ninth Circuit. So let's do it. One of Mr. Mendoza-Linares' arguments was a straight question of law, trying to fit within the jurisdictional savings clause at INA Section 242D. Mr. Mendoza-Linares argued that the asylum officer and IJ erred by relying on the transit bar, as that bar prevented Mr. Mendoza-Linares from obtaining constitutionally protected due process. And I mean, yes, indeed, that is in fact exactly what happened. He was entirely prevented from bringing any asylum claim. No process at all. Unfortunately, realizing some of immigration attorneys' biggest fears following Justice Alito's Thuraissigiam decision 2 terms ago, the Ninth Circuit relied on that decision to hold that, quote, as an arriving immigrant caught at the border, Mr. Mendoza-Linares has no constitutional rights regarding his application for asylum, end quote. None, said the majority. Quote, denying all judicial review of constitutional questions concerning admission of an arriving alien does not raise a substantial constitutional question, end quote. So, if you don't have constitutional rights, as Justice Alito has now explained in more than one recent decision, how can they be violated? See how that works? And this is how it works in the immigration context. The Supreme Court's decision in Thuraissigiam, by the way, overturned a Ninth Circuit decision protecting constitutional rights. By the way. So no constitutional rights to be protected. But all of that was actually the Ninth Circuit's alternative holding in this case. The court first actually held that under the web of INA Section 242 jurisdiction stripping provisions, it lacked jurisdiction to review the issues unless, maybe, Mr. Mendoza-Linares brought a cognizable challenge under INA Section 242E. For a variety of reasons, the Ninth Circuit held that no Section 242E claim lied, if that section was even applicable to this case at all. It gets really complicated, and I suggest you give it a read to fully comprehend the maze that is the INA's jurisdiction stripping provisions. I mean, all told, it's a 75-page decision, with countless interlocking statutes and regulations. In fact, it appears that the Ninth Circuit is also holding that Congress precluded even constitutional review of the issues presented in this case. There's a lot going on and a lot of legal logics employed to rule against Mr. Mendoza-Linares and uphold the application of the Trump administration's 8-month transit bar. And perhaps the Ninth Circuit will go en banc. But for now and at base, quote, Congress could scarcely have been more comprehensive in its articulation of the general prohibition on judicial review of expedited removal orders, end quote. At least when it comes to specific individual challenges like Mr. Mendoza-Linares. While lots of this decision is about expedited removal and credible fear interviews generally, my takeaway is this. Thank God the transit bar isn't around anymore. And oh, by the way, in the concluding footnote, the Ninth Circuit majority makes clear that all of this anti-administrative agency case law designed to tear down the administrative state percolating in the Fifth Circuit based on the nondelegation doctrine, primarily if not entirely in the SEC and EPA contexts, is not applicable to the immigration agencies. That is because, citing to Justice Alito again, Congress has provided a, quote, intelligible principle, end quote, for DHS and DOJ to govern immigration. According to the court in a footnote, DHS and DOJ haven't gone rogue from Congress like the Fifth Circuit believes the SEC and maybe the EPA have. Fun stuff. The next legal frontier. Keep an eye on what happens next with the non-delegation doctrine at the Supreme Court and how it might apply to the immigration agencies, Ninth Circuit footnote notwithstanding. Judge Graber seems a bit horrified in dissent. And I have one more thought, more immigration specific than the non-delegation doctrine. As I mentioned at the top of the episode, it appears that Mr. Mendoza-Linares hopped a fence and physically entered the United States. Unaddressed in this decision is the fact that DHS ordered Mr. Mendoza-Linares expeditiously removed under INA Section 212A7AII rather than Section 212A6AI. That would seem to run afoul of the Ninth Circuit's en banc decision in Torres v. Barr, discussed on episode 22 of the podcast. Because Mr. Mendoza-Linares, it appears, was physically in the United States. He wasn't an applicant for admission at the border. Thuraissigiam and constitutional rights notwithstanding, Mr. Mendoza-Linares was in the U.S. when apprehended, it appears. He wasn't an applicant for admission, according to Torres. He had already entered without inspection or admission. Might the Ninth Circuit have jurisdiction to review whether Mr. Mendoza-Linares was erroneously ordered removed in the first place? I think it might. Although it did provide about a dozen jurisdictional hurdles to jump over in this decision. And that is Mendoza-Linares v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.